Hi, welcome to Integrative Lawyers of the World, where we believe that lawyers can and do contribute to the healing of the world. We believe this because we know lawyers who are doing just this. Hi, I'm your host, Carrie Raleigh, and our guest this episode is Susanne Meer. Susanne is a creative lawyer, strategic illustrator, philosopher, and visual thinking facilitator. Prior to emigrating to Denver, Colorado, in the United States, Susanne has worked 12 years as an attorney and corporate lawyer in the Netherlands. She is currently the program manager for the Office of Dispute Resolution of Colorado. For over a decade, Susanne has operated her own design, training, and consulting business to support lawyers and others in user-friendly visual communication and creative thinking. She's the author of Visual Language for Lawyers. She teaches visual thinking skills as part of a design thinking program at the University of Denver, Colorado. Thank you for joining us today. I hope you enjoy this conversation. And to find out more about the integrative law movement or to listen to additional episodes of Integrative Lawyers of the World, go to our website at www.integrativelaw.com. I hope you enjoy our conversation. Hi, Susanne. Thank you so much for joining us and being part of Integrative Lawyers of the World. For us to start our conversation, can you just tell us a little bit about yourself?
Thank you, Carrie, for inviting me to be on this podcast. So happy to be here. And I live in Colorado since 2005. I am originally from the Netherlands, and that's where I went to law school and practiced law in a more traditional way. And then towards the end of that, I started to see just different possibilities to work with law. And I wrote a book at that time in Dutch called Visual Language for Lawyers. And that really was the segue for me into much more creative approaches to law and much more integrative approaches to law from then on. And it kind of morphed into different versions and different formats and different projects and different businesses and different roles over time. But I still really care about law and legal practice and what it means in our communities and societies and in our world. And I also still feel that the legal profession has a big role and a big opportunity to make that a lot more accessible for more people. And for me, the medium to do that is to work with visuals and creative practices.
Well, thank you so much for joining us. I'm pausing because I'm thinking about the trajectory of your career, how you worked in more of a traditional law setting, and then you followed your creative thinking and creative skills to help law become more accessible to others. And part of that was through your book, Visual Language for Lawyers. What do you mean by visual language?
Yeah. So it's using graphics and graphic diagrams and information graphics to explain legal information and to make it accessible. And to how I see it is as a packaging around legal information. And if you think of granola, it's healthy, it's nutritious, but it's not very accessible. So to eat it or to even take it with you, take a granola bar and then you can actually do something with it. So that's how I think of visual language for law, that you make it accessible, make it packageable, and you filter as a lawyer from your professional perspective what people need to know, what they need to do, what they need to take with them without loading them up with your whole baggage.
Yeah.
And I think that is often the reason why I call it language is because I feel it's a translation process between the original source language and a new language that users of legal information can understand and work with and make their own.
Several lawyers out there, myself included, can all think of times where we're explaining something to a client or you're talking about a legal issue to family and friends, and there's always that moment where their eyes start to gloss over and you're like, wait a second here, they're not getting what I'm saying or there's missing something. So,
and one piece I'd like to add to that is that actually, to my surprise, I found that this is also very useful in corporate law settings or government law settings. So originally I thought it would only be for sort of the general public that would have difficulty to understand, but another factor is, of course, information overload and time and expectations. I wrote the book in 2004. That was pre-iPhone. So the expectation for screen communication, visual communication, and bite size, it was pre-Twitter, it was pre all of that. So the bandwidth to, even if you can, cognitively can, or even have the legal knowledge to do that, or another, let's say you're an accountant working in an organization, you have the academic ability to understand a long legal memo, but you don't have the time and attention span. So that's also where that translation responsibility comes in for lawyers, to make sure that whoever is the user of legal information can better work with it.
Yeah, that is so important. And I found one of the things that I struggled with was when clients came to me for like to draft a contract for them. I want it to be only 3 pages long, but I want you to cover all these things in here and here, and I want you to put it in a way that everyone understands. And for me, a way to help people understand it is to sometimes put in examples into the contract. But then that makes the contract longer. And so I found it so I could see how sometimes like some of your visual language might be able to help a lawyer meet the expectations of the client a little bit better in terms of, I mean, sometimes you can't get it as small as they want it to be or as short as they want it to be, but maybe you can get closer.
An example of that would be putting a timeline in a contract rather than write out if this happens, if that happens, if that happens, if that happens, before it is, after it. So that could save space. But typically how I train lawyers, and also to comfort them, is like, think of this as an addition, a complementary tool, to not have the feeling like, oh, I'm going to lose the solidity of legal language and legal responsibility that makes lawyers very anxious. So it's like, okay, think of it as that front page, that wrapper around it.
You recently published an article, Creative Leadership to Bring Design Thinking and Other Innovation Models to Life in Legal Business. You talk about design thinking and design thinking as a tool for innovation that can be used by lawyers in the legal business. What do you mean, or what is design thinking?
Design thinking is a framework that now becomes known in the legal field as legal design thinking, and it's an application of a model that has been developed in the world of designing and kind of an academic thinking about designing, and really, in that sense, a meta model about what are the steps in design processes that we can apply to whatever question or problem. And so it has different steps. It's like empathy and prototyping and testing. So not rocket science, but it's a helpful framework that breaks that up in phases and is really good to think from the user's perspective. And that, of course, is just as relevant in legal problem solving as in, let's say, building a new vacuum or a new computer app.
The user perspective could be the client. The user perspective, I guess if you're a trial lawyer, it might be the jury. How is the jury going to perceive something like this? Or it depends on, if you're on the management side of the law firm, the user could be your employees, your associates, and support staff.
Yeah, exactly.
So there's not one set application where it could be used. It could be used in almost any application or any issue facing lawyers or any business.
Yeah.
Okay.
Yeah.
Why do you think it's important for lawyers to understand what it is and to learn how to use it or develop it?
What I find is that lawyers are very centered, focused, skillful in working from the legal content, their legal expertise. their legal education, their legal role even, and have a hard time to switch to being in the user's shoes. And so empathy, it's such a generic and standard term, but to actually do it, it means stepping into a more unknown space, because it's really comfortable to be in your own expertise realm,
Yeah.
and have authority and standing and trust that what you're saying makes sense. And that is a lot harder when you step in someone else's shoes and even have to do that, that flexibility that you just named by saying, oh, users could be your clients, could be a judge, could be the management in your organization. If you're in a government organization, your users could be team members from other professions. And then once you do that, you find out that you don't really know how they think or what they need or what they understand. And in some one method that I like, it's Common Craft is the book, and it's an explanation method that says, what is the explanation problem? And in trainings with lawyers, when we do this redesigning of legal information into a visual support, when you ask, like, what is the explanation problem that you run into, it's like it's a really hard question. So what is it that they don't get? What do you see? When do you see people glancing over? When do you see them kind of numb out, phase out, go do other things? Probably that's where something's happening. It could be it's not interesting, it's not focused, or doesn't make sense. So that's where you need to go into that little bit of an unknown. Like, I don't know exactly what you need. And that's uncomfortable to even realize. Like, lawyers like to be really certain that what they contribute is super relevant. And that assumption is tested once you go in a design thinking mind, where you try to make something that makes sense from the user's perspective. And it doesn't mean that it doesn't need to ultimately be solid from your perspective, right? If you're designing a vacuum, yeah, of course it needs to do what it needs to do, but you first go out how someone of, let's say, a different size or a different ability or a different mobility would use that. And then you go figure out how you make that do the job. And that's the same with legal design thinking. You line up, you come in from the perspective of the user, and then you make sure that you meet their needs from your professional responsibility, your professional solidity. And so why is it important? It's a cognitive agility. It's both a creative and a cognitive agility for lawyers. And design thinking can break that down in steps. And since it is, now I'm going to bridge it to something else that I feel is really specific to lawyers, and that is best practices. Design thinking by now has been established in the business world, and even in the legal world. You see it come up, especially like the legal tech tends to be the more innovative part of the profession. I think many people have heard the term now, and if they would look or research it, there's lots of literature, there's lots of training. It's accepted. And it's more accepted than saying, oh, we're going to do a creative brainstorm. And I think that provides some structure and some comfort. And the point that I wanted to make about best practices, lawyers come from precedent. That's where the ground, and like you said, lawyers want to their professional role is to mitigate risk, to assess risk, to think like that. So nothing wrong with that, but it can become too focused on that, too kind of static in that sense. And that fluidity is where design thinking comes in. But if you ask, like, oh, who has done this before? Who has used this before? Does it make sense? Then the fact that it's a by now solid framework helps lawyers to want to use the term and look into it more.
Lawyers wanting to follow and adhere to best practices. I'd like something that you said in your article. Instead of following established best practices that was set forth in the past, use the design thinking model and formula to create the best practices going forward, to create your own set of best practices. And that can lead to improvement instead of just staying in the same place or doing the same thing over and over again.
Right.
We have to advise our clients, and we have to make sure a lot of the elements for the different causes of actions have a reasonableness standard in there. And that reasonable standard, we draw upon what would a reasonable person think. We draw upon best practices. But as I'm talking this through out loud, I think there will be a question at some point. But the design thinking model, the first step is empathy. And if our empathy puts us into the end user, that should automatically get us thinking about what would the reasonable person think.
I liked how you unpacked that and kind of went on a little inquiry with that. But yes, at first glance, like that precedent or best practice or reasonable standard is not just built in the mindset of the lawyer, but also in the substance, like the substantive law and references and tools that you use to create or write whatever you make for a client. So there is a force towards repeating what has been done, but then I would say a creative mindset and I take that broader than just the design thinking framework, but let's say the design thinking framework is you can go incremental. It doesn't mean, oh, now you're going with empathy and with problem solving, you go prototype. It means you throw everything out. Maybe it means you add, let's say you keep the same text, but you add some icons for reference, or you create a visual summary that adds to what you used to do. So first of all, it can be small. It doesn't mean it can't be done at all. And the other part is reasonable standard. That's where I'm going already, like in the direction where you went. Like if empathy is the way to look at that or to examine that, I would say it's pretty unreasonable to expect that people read a licensing agreement before they download an app and understand that. And it could be 80 pages fine print, not in plain language, is not intended to be read, really. That's to me very unreasonable. And I can come up with a million examples of things that are pretty unreasonable. So you could say, okay, yes, there's a standard in practice, but stretch what is a reasonable standard. Can that mean, yeah, this is the basic, but we can make it better and it's still reasonable?
One thing I like about the process, you read more and more about the importance of innovation. I know the law. I know studying the law. I'm not an inventor. I'm not a scientist. You want me to innovate, feeling a little overwhelmed by it. But then when you read through and it out that the model itself provides the 6 steps, and I'm getting this from your article: 1, empathy; 2, define; 3, ideate; 4, prototype; 5, test; 6, implement. I love having a process and steps. Now I know what I need to do, and now I can do it. Now it's not some unconquerable mystery. Have you used design thinking with lawyers? And I know you teach at the University of Denver, Colorado. Do you use this with your students? Do you use it with lawyers or law firms?
I don't do that anymore. It ended before COVID, during COVID, and it wasn't resumed in that same way. And it was with business students, so it was not at the law school. So it was applied somewhat differently for business innovation projects that they came up with. But to your question, like how have I applied it in law? It's like in my own work, I've used it before working with the Office of Dispute Resolution. I worked as a self-help coordinator at the local court in a small rural area in Colorado. And Colorado has self-help coordinators at every court, and they help pro se parties to navigate the process. And they obviously can give legal advice, but they give general legal information, assistance with forms, refer to legal clinics, things like that. So how I've used design thinking is with self-help information, and to just identify, like, what do I see where people have maybe the most stress. It doesn't mean they can't understand, but this is the most stressful. So the first visual tools that I created for the court were around protection orders, which of course is by nature a heightened subject. And again, like, you can have temporarily less cognitive bandwidth, whether that's due to stress or a disability or trauma or whatever that is. But then the empathy is, I see people really freak out with a protection order and also really don't understand what it is. So that's the explanation problem. What is it? How do you get ready for it? How does it work with a temporary protection order? How does it work with a permanent order? And so that's where I went through the steps, first for myself, like, okay, and then empathizing with parties that need to get ready for a filing, for a hearing, etc. And then defining what can I do. And for me, the defining was like, okay, what is the scope of information? Of course, I cannot give legal advice, so it's keeping it general, and keeping it process oriented in a very practical way for them. And then ideate, like, how can I do that? Well, then for me, the form was already given. It was clear that I was going to create visual charts for them, visual guidance. But then still ideating is, and what kind of images am I going to use? What kind of parts of language am I going to use? Who do I need to get on board? Do I need to get judges, court staff on board? Can I do this on my own in a small local court, or does this have to be approved somewhere? All those elements go into the sort of creative mix. And then there's a prototype, and that testing was done with court staff first, that normally explains this at the counter all the time. And then they actually come up with things. They say, the biggest problem for people is service, personal service. They don't get it. They don't have the money. They don't know how to do it. Can you explain how that part works? Okay, like that, I hadn't identified that as the biggest need. And then testing, implementing. And so those are steps. And maybe this is an example. It's not innovating the court process. It's not innovating how protection orders work. It is innovating the experience of a party that has to deal with that.
We are taking a brief break from this conversation to ask for your financial support. With each episode, we hope you can see how lawyers and peacemakers like you are contributing to the healing of the world. It takes many kinds of resources for the integrative law movement to keep going and affecting change. Your monetary donation can help us continue this important work by supporting the activities and the members of this community. Each contribution goes to promote the stability and accessibility of the movement and to support basic expenses like our Mighty Network group, web hosting, social media and event management, and this Integrative Lawyers of the World podcast. Because we like to give people choices, we have ongoing monthly options to match your budget, or you can make a one-time donation. Thanks to our non-profit corporate sponsor, the Renaissance Law Society, US supporters are able to make tax-deductible donations. Supporters from other countries, please check your local tax laws. To help establish confidence in your choice to support us, we have set up an open, collective, transparent plan to track how the community money is spent. For ways to support the integrative law movement and our world-changing work, go to our website at www.integrativelaw.com and click on Support the Movement tab at the top of the page. Another great way to support us is to rate us 5 stars and comment, like, follow or subscribe to us on iTunes, Spotify, Google, YouTube, or your favorite podcast platform. These ratings and interactions help us get seen and heard by even more people to make an even stronger impact. Thank you for your support and spending time with us today. Enjoy the rest of this conversation.
In the article, you have 4 suggestions on how lawyers or law firms can implement or improve their design thinking and creativity. 1, recognize creativity. 2, understand the basics of psychology of creativity. 3, teach lawyers to stretch their creative muscles. And 4, bring legal artists in residence to the office or to the firm. I'd love that last suggestion, but we'll stay tuned, everyone. We will get to that one last, but let's start at the beginning. Recognize creativity.
I'm going to make a little sidestep here. One of the things I've done at some point in my business is do individual visual coaching with people. So I would have a coaching conversation and I would take visual notes, kind of a live whiteboard, live mind mapping drawing, and then they would see it and would have some distance from it and could respond to it. So they would see kind of the conversation visually on the wall. And what the type of questions that I was working with often was a new project, a new career, a life phase change. And to my surprise, it almost always came down to, I want to be more creative and I don't know how to do it. And I'm not creative, and often like very emotional actually for people. And then I would sometimes say, but do you know, I just wrote here, you may be working in finance, but I wrote that you do a fashion blog, right? Or I, a business consultant, like, can you tell me more about that music that you just told me about? So it's pointing out where people already express creativity in their life. And then it's like, okay, there's a dot. What else? How can you connect that? And I do the same in the trainings on legal visualization with lawyers. The first question is, how are you already doing this or doing something creative? And people will often say, no, it's similar to people who say, I don't sing, I can draw. Well, I like to cook, I like fashion, I like gardening. I'm like, okay, there we go. So recognizing creativity is, first of all, it doesn't have to be drawing, painting, visual arts is how we typically tend to think of it, but it could look a million ways. And it could also be creative thinking and to acknowledge people that do those things, not as a hobby outside of work, because in the response that I get, it means people take that fashion blog out of their being and they identify as, I work in finance. I'm not creative and I'm miserable and I don't know how to get there. It's like, if in meetings with legal teams or legal trainings, we talk about hobbies or art or music or only as the coffee topic, then somehow it's not part of work. And that's where I would start. Like everyone, first of all, with coworkers, but if you're in a leadership position, like to bring that in and to recognize that that's where it lives. And I think law is maybe more than other professions has filtered that out. And I think that comes from the really abstract-minded nature of the work and abstract-minded nature of legal training. We filter out, we sift really well, but we squeeze the life out of it.
As a litigation attorney, when I had to do briefs or memos, filing motions or memorandum or briefs to the court, you have to tell the court the story, before you apply the law and the analysis, you first have to give a background, and that's telling a story. And if you could do that in a way that captures the court's interest, that's helpful for the rest of it. That requires storytelling. Most of my career was in litigation and trial lawyers. And I think a lot of us are closeted actors or actresses wannabes, and we have that outlet. So I think there are many in the legal profession would probably welcome an opportunity to be more creative.
Yeah. And it is what you filter out to acknowledge, right? You can say, I'm so glad you followed the best practice. Or that was such a fresh approach in how you prepared your argument or how you role played that with your coworkers. Then you point out what is fresh versus what was compliant. And both are valid, but I think the tendency to and then for younger lawyers and younger professionals, like then that's what you hear. That's what you see qualifies as being good at what you do. And you're totally right on. I think to litigate, you have to be really creative, and you have to be like work with your body, right? It's a whole body performance. To then one example of bringing in creativity, acknowledging is like, oh, I'm like if someone would say, oh, I have to tell this story about whatever the car accident. And I'm just thinking in Colorado, there's a few law firms that have these big ads like, oh, were you hit by a big truck? Then I imagine, oh, they're specialized in big truck accidents. So they probably have a lot of big truck accident stories. But then if you work there, can each other like to totally present that story in a different way or demonstrate it in a different way? It's like, can you, and even if you're not going to do it, can you cultivate that creative agility and ability by at least saying people, hey, okay, it was okay, but try it again. Can you bring it more to life?
The 6 steps of the design thinking, you have that safe space. The ideate is the experimenting process, and the prototype is making it, but there are those last 2 steps. Step number 5 is testing it. That's where you're going to be protecting yourself from malpractice. And if you have a safe space where you could do that with partners and other lawyers, you're helping everyone.
And also to not think of everything as a deliverable, as a product, right? As an artist, you make lots of sketches, like lots of that is personal process. If you're a pianist, you do your finger exercise. If you're a musician, you do improv. Doesn't mean you're going to take that to the stage. If you're a dancer, you move your body all the time. That's not your performance. And to bring that element, okay, that's where I experiment. Like maybe if you're the truck personal liability car truck attorney, maybe you're not going to tell that entirely different story, but you've told 3 versions to your coworkers or to your children, and now you feel fresh and like maybe there's a little more juice and I'm lighter and I am more flexible. Or maybe you find out, okay, you're telling the same story, but something happens during the trial. And now all of a sudden you can tap in one of your BCD stories. So I would say it's that not everything is a deliverable creative process. And that is in one of the tips that I had that you named in the 4.
The basic psychology of creativity?
Yeah, and that is understanding creative process and psychology. It's like it starts with I can draw, I can sing. I'm not going to speak in front of an audience, right? It's I can't. It's a creative block. It expresses as a creative block, but it's really a serious personal emotional block that many people carry in some form. Could be whatever the cause is and whatever the extent and the depth is. But to simply ignore it or don't understand anything about that, that would be a mistake. That would be forcing someone, you go on the stage. Now let's say you have a very introverted person and now it becomes a performance evaluation criterion. Like now everyone, we value creativity. So now we all go perform something. Well, that is not necessarily what creativity looks like for everyone. Probably likely not. Also recognizing creativity is very intimate. It's very personal. When it's real, when it's alive, it's personal. And maybe it's just like, hey, find some new words in your writing, like to take small steps. And as a leader, to be sensitive to that, like you would do with other types of risk taking. And to actually acknowledge this is pretty personal for people to be creative, to be a little in the experiment space, to do something that is not scripted, not predicted. That is a process. And I can speak for myself. I have been on a long journey of becoming an artist, like from being much more of an uptight lawyer that identified as a lawyer. I would be the person who said, yeah, I do the fashion blog, but that's not me. So I feel in leadership, that is an important responsibility. And the only way you can really do that well is to first, as a leader, do it yourself. Like learn something for yourself about your own creative process. There's lots of good books about the psychology of creative process, and some people would be more attracted to the innovation business side of that, but there's still a lot of, in the article I have some suggestions that still bring in that psychology part, and then others could be more on the real psychology creativity part.
Where I see a potential restraint, and maybe going through the design thinking process is the way to overcome this restraint, is when you were talking about not thinking of everything that you do as a deliverable so that you can use the creative process. The billable hour model is a big restraint on that, because as a lawyer you are held to trying to have everything that you do every second of your day to be accountable so that you can bill it for the client. And do you have any suggestions on how to overcome I don't know if it's an actual restraint or just a perceived restraint of the billable hour on the creative process?
Yeah, I can speak to that. And I've worked in those environments, so I can relate to that. So then I would say the first part could be where you create something for a client that you could use repeatedly. Like, let's say you're a divorce attorney, you repeatedly explain how the case is going to go, what the steps are going to be. Then if you create a visual or another creative approach, whatever it speaks to you, for that conversation, maybe it's a little video, maybe it's a little role play, then that's where you could make something and make something that you can use again. And how that then works, how you account for that in your billable hours and system, if you can repeat bill or not, or if that goes into the knowledge base that is charged for in a different way, that would be very like individually for individual firms to decide how to handle that. But I think there are repeat things that can be worth the time and investment. And the other area where I see it is in, let's say, newsletters, marketing presentations, network presentations. Those are places where you're already investing non-billable time. So that's where you could create, let's say, that visual about what is the divorce process. Let's say you go give that presentation at a chamber of commerce, then that's where you can create something new. You put in your time instead of a PowerPoint or instead of whatever. You say, okay, I'm going to do this a little bit differently. So it's again then being creative. Where can I, within the constraints of the framework of this organization, and maybe have team conversations like, oh, where can we allocate some variety in our approach? And I would say it pays off. Like if you have to do the same thing over and over again under high billable hour pressure, a well-being element would be, for me at least, to have some variety in how I can take on a task, or so find some flexibility.
And if it is one of those things that you can do over and over again, maybe you charge a flat rate for that instead of a billable hour for that part of. I've seen hybrid billable flat rates used, so that could be part of the, defining and ideating part of the issue.
Yeah, and with some clients, you might trainer, and some work might be in onboarding team members that work for the client. Let's say you work with the legal team of a client, then there might be repeat work there that you do. So think of those where it pays off to invest in something different.
The last thing on the list was bring legal artist in residence to the office or the firm. What do you mean by that?
Well, first, the artist in residence is someone who is like a professional artist, a practicing artist that is hired by a company to be a part of the organization for a certain period of time. So it's different than having an arts committee with a budget select the art pieces for the waiting area. That is different. That is very separate from the organization and the people that work in the organization, other than the people who get to make the decisions about the pre-selected artworks. So this is about bringing an artist in that, and then there's a variety of models, but that interacts with the company. And it could be someone who has more of a fly on the wall role and then creates art out of that. And it could be a movement piece or a theater piece. Like, how do people live in this building? It could, and I'll try to get to something more legal, but in general, it could be more interactive, where an artist engages, let's say, staff in creative workshops, whether that's painting or music or movement or design thinking.
The artist in the office creating their artwork, and in some instances, they may also interact with the staff through workshops or things like that. But is the idea behind this that sometimes creative energy, just being around creative energy, helps inspire creative energy?
Yes, that is one of the ideas. That it's like, I don't know if you like books and you walk in a bookstore, in a library, if you go to a dance performance and you like movement, you somehow want to move along. You actually maybe feel like you could dance a little bit better than you actually can, but it's taking in some of that. I love being in artist studios, just seeing their supplies. Like, people who like woodworking like to see other people woodworking. And sometimes, even when you don't know that medium or form, there's still something about seeing people interact with something that isn't predefined and make what they're making. And then the other part would be the exposure and interaction by someone who thinks very differently. That they're not there to make the same billable hours. They're not there to work risk mitigating. That's not their role. So it's bringing, in that sense, a diversity of perspective and being in the mix. Yeah. And then in a legal sense, like, I'd like to try to give an example of what this could look like in the legal space. Let's say you bring actors in, and you would not give them the assignment like role play mediation or role play difficult customer conversation. That are all very output work based, right? They're related to existing work process. But what if you bring those artists in, or actors in, to walk and be in the space for a while? And they might start to, like, maybe you've seen that in public space or in a shopping mall, where there's kind of, I forgot the word, but when something's happening, it's a surprise, and they're part of an act, a performance. Maybe they start to move differently. Maybe they walk a lot faster. Maybe they slow down. They can change the pace of how people are moving. And then maybe there is some kind of theater workshop that then you could then apply to, how do you use this in presentations? How do you use this in working with clients? How do you use this in working in the courtroom? So, but I think the difference is, it's not a training that is mimicking the skill set in the context that you need it for, but it's showing something in a different context to open up that experiment and then bring it back into your work role.
If you're working at a firm and they brought in an artist in residence, just feeling a new energy in the place. That's what I feel like it would be.
Yeah. And one of the courts in the district that I work in, the clerk of court brought in painting supplies in the lunchroom, and it was just always there. It was like a break room, but you could just go and paint. And that's an example. It doesn't need necessarily an artist in residence, but there was a studio space in the office.
Oh, that's a great idea. Paint books, or even bringing like coloring books and crayons and stuff, and have that.
And then people probably start bringing their own art supplies that they
Yeah.
like or that they don't use. Or
I would love that, an art room in the law firm.
there's one thing that I'd like to mention is that this may sound for some listeners, viewers, foreign or too far out of the box or uncomfortable, but to bring in that a lot of these skills are already part of the legal skill set, whether and the lawyer as a whole being skill set, whether that's in a hobby space or a different space. But if you think of arguing, debating, conflict resolution, advocating, all those skills take a lot of perspective taking. And that is the essence of empathy. And that is a big piece of being creative and flexible. And in the article, I give a lot of examples to really emphasize this is how you already do it, but you can use it more and kind of loosen it up. But it's not an entirely different world. It's not like, oh, that's not me. It's like actually looking, oh, how is it already in our actually strength, the genius that lawyers typically have, the type of genius, I would say, that actually has definitely creative elements in it.
For those who are listening, in the show notes, I will provide a link to where you can find the article. And it goes into a lot more detail and gives some examples of the things that we talked about today. At the start of our conversation, you had mentioned that, and this may have been before we pressed record, you had mentioned to me that you just completed your philosophy degree. You went back to school for philosophy?
Yes. I went back 8 years ago. I was just interested in philosophy, and I fell in love with it for the really language articulation, and that it wasn't just a mental or cognitive exercise, but it really brought things to life for me in a new way. And I see that as the umbrella there is sense making. All the things I explore and do somehow lead back to sense making, and it was an aspect of sense making that I hadn't developed to the extent that I wanted. So first I did just more like courses and making sense of the world, making sense of people, making sense of ideas. Yeah.
I mentioned that because I've always been interested in philosophy, but I haven't actually taken steps. I took one philosophy course in undergrad, and ever since then it's just always been on the side that I've never really picked up.
I have a master's in continental philosophy, so it's a part of philosophy. And then when I graduated, I don't know, 2-3 years ago, I took training as a philosophical practitioner, and that was kind of the plan from the beginning, to make it really applied to life questions. And a philosophical practitioner, you see, there's versions that are more in personal work, like philosophical counseling, coaching, or more philosophical consultants, business trainers that work on questions of meaning and ethics and all kinds of philosophical questions apply to personal life or professional life or the life of an organization.
What does integrative law or being an integrative lawyer mean to you?
To me, I could first of all overlay that means being a creative lawyer. That means being fresh and seeing where there's resources, where there's ideas, where there's needs, and weaving them together in a meaningful way for the people you work with at that point. And that means an integrative lawyer for me is someone who is responsive to the need of the people you work with, and in that sense, someone who has a responsibility to wear this role, to wear this hat in our society, and to not just have that as your own profession, but to be in some way a representative of the role that law has in society, and in a way also the ideal role or more ideal role, and to work to improve the field and to to make it fair for the people who work in all their ways with law, with legal principles, legal professionals. And then one element is also an integrative lawyer is someone who walks the talk, like who learns and grows and develops themselves into a well-rounded, caring human being in life, in work, in family, in community, and that's a big ambition. But I feel that ambition is part of being an integrative lawyer too.
Very well said. Thank you so much for being a part of Integrative Lawyers of the World. It was a very interesting conversation. Thank you very much.
Thank you so much, Carrie.